ensure greater and more effective scrutiny of rights in legislation, and secondly, rights are considered by public authorities in decision making?
My criticism of the Victorian legislation was primarily one of hypocrisy, that it sets out to comply with certain standards, but then the government subverts those standards. My view is that the government should be held accountable in a democratic way for not complying with its own standards or not complying with appropriate standards, and that's what I've done in a number of my speeches before the Parliament. That's what the Scrutiny of Acts and Regulations Committee of the Parliament does. I don't favour going the other way, and
so are you saying that the scrutiny applied to legislation before it's passed to see if it's compliant with the Charter, that process doesn't work? Is that what you're saying?
I'm saying the current government doesn't comply with its own Charter, and I think that if you went down a parliamentary model, you would want to ensure that the scrutiny body, for example the Scrutiny of Acts and Regulations Committee, had its reports taken more seriously. That's not to say that Parliament would necessarily agree with those reports, but I think they deserve more attention than they generally do in parliamentary debate. But I was going to make the point in response to what I think is implicit in your question. Well, given that this dialogue model doesn't work, why don't you allow the courts, why don't you make the Charter rights or the International Covenant binding as a matter of domestic law? I think that would be, in a sense, even worse, because that would completely take these issues out of the democratic arena and be having the courts pass judgment on them. So I suppose my bottom line is, I think Australia, by and large, has had a set of laws that stand up pretty well to scrutiny against international benchmarks. I'm not saying it's universal, but we stand up pretty well, and I think it's perfectly appropriate that any opposed law be benchmarked against those international standards. And then it's up to the community to make a decision as to whether or not it agrees with what's proposed in any particular law. I would say if you're going to do that, then let's do it against international benchmarks and not against these manipulated benchmarks that we've got here in Victoria. I mean, Brian quite rightly referred earlier to the right to be freedom from torture. Well, that's a right that under the Victorian legislation can be abrogated. Now, why is that so in Victoria? Are we not in breach of the International Covenant and in breach of Australia's international obligations by having that provision in our Victorian legislation?
But Brian Walters, what do you make of those comments?
There's several things that could be said, but briefly what I'd say is that we do have a system where the Scrutiny of Acts and Regulations Committee does look at legislation from a human rights point of view now, and I think that's a great step forward.
Is it an effective system?
It's not enough in itself. I mean, we talked about the Control of Weapons Act before, the knife searching. When the government introduced that, they said up front, this is not compatible with the Charter of Human Rights and Responsibilities. So that was the end of that. I think in the end, you need to have the courts with another function. I mean, that's the way it works, that the courts and the executive and the Parliament don't always agree. So you have a dialogue. In the countries where they do all agree, most of us wouldn't want to live. You know, that's the whole point. And so, you know, I would say not only should we have the dialogue, but we should have a standalone remedy for anything that we say is a right. Because otherwise we don't really have the right fully protected and accountable.
What do you mean by the standalone remedy?
A right to sue, a right to take action in the courts on that.
For breach of Charter rights.
For breach of a Charter right.
Is litigation the way forward, though?
Look, most of what ultimately it has the educative function, because if people in government know that there's a risk that they're likely to be taken to court if they don't comply with the Charter, it concentrates their minds a lot more than if they know it's just something that's, you know, touchy-feely, but not with real teeth in the end.
Robert Clark,
Yes.
what do you reckon? Would that focus the minds of our politicians and bureaucrats?
Well, can I sort of toss a question across to Brian, if I may? Are you saying, for example, in the Monsilovic case, the charter should have been such that the court would have struck down the law in question about reverse onus of proof, declared it void, and because it was inconsistent with the charter rights?
Yeah, because at the moment, it is a different issue as to whether you can strike down legislation, but where it's the decision of an authority under legislation, but it's in breach of the charter, then I think there ought to be a standalone right. At the current situation where you get a declaration of incompatibility, it's a booby prize if you're the litigant, because you still lose the case, right? You still get the bad result, but Parliament has to go and reconsider whether it would have done it differently for the next person. I'm not sure that's the best system either.
Indeed.
What do you think of litigants getting damages, monetary damages, for a breach of charter rights?
I don't think that's a desirable approach. I mean, in a sense, that is one manifestation of saying that the charter rights are binding and overriding as domestic law in Victoria. And my view is that these charter rights are phrased in very sweeping terms. They are as much policy document, or they're statements of broad principle at a policy, at an international level. To take them and apply them word for word as domestic law creates a whole lot of issues of interpretation, which tries to graft one jurisprudential model on top of an existing framework of common law and statutory rights, and is likely to lead to unexpected consequences and perverse results, or certainly results that are out of line with community expectations. And you can talk about all sorts of examples. I think I caught the tail end of one discussion on radio today, which is, as far as I could make out, was about whether a citizen was entitled to have a cross erected a crucifix erected in their front garden. Now, should that be directly litigated as a charter issue, and that person's right determined on the basis of a court's application of the charter, or do you say this is a matter of public policy and of planning law? Similarly, issues about children's Christmas plays, for example, can or should those be litigated as infringements on rights of freedom of religion, or do you say no, these are public policy issues where the community strikes a balance as to what's fair and reasonable?
I've got to ask you, I mean, there are all the cases in the USA of the Christmas tree in the town square, and various communities saying that's not on, and that becoming a constitutional issue. Brian Walters, how do you respond to that?
Well, a few things. First of all, the first thing I want to say is that the great virtue, one of the really great virtues of the Charter is that it plugs our our legal system into the international jurisprudence. And time and again what I've found is that something that crops up here has already occurred somewhere else. And they've thought about it and they've thought it through. And so there's all this international jurisprudence which we can now call on, instead of being really very isolated in the international legal world. That's a really powerful advantage, because we can learn from others. Second thing I want to say is that our common law system is not the world's greatest system. It's got a lot of things wrong with it. It's great if you're rich and powerful. It's not so good if you're powerless. I mean, one example would be the Al-Khattab case, not a Victorian case, but a federal case, where Mr Al-Khattab was a Palestinian who had failed in his application for asylum and was set to be deported, but there was no state to which he could be deported. And he was held for years behind razor wire in the desert. And when he finally went to the High Court said by 4 justices to 3 that that was okay. He could be held, although he'd committed no crime, for administrative detention for the rest of his life. It's a shocking decision. That's the common law. Now, one of the four in the majority, Justice McHugh, on his retirement said, had there